calling into question the integrity and credibility of the jury.
You don't question the province of the jury.
Mr. Brennan will be paid between $400,000 and $500,000.
A lot of attention on this case. A lot of people watching.
The Karen Reed verdict is now history. The jurors have spoken, as have a lot of others. What lessons do we learn going forward? Mark Bederow and Yoli join me in this episode. I'm Andrew Myers. This is About the Law, and joining me this week is Mark Bederow. Mark, thank you for joining me.
How are you?
And also Yolie Medina. Yoli, thanks for joining me again as co-host. I appreciate it.
Thanks for having me.
How are you folks doing? Mark, now that we've had 10 days or 2 weeks since the verdict, you must be tired.
I'm very tired, but you know, the world of a lawyer, there's always things to do. On to the next one. Much to do. So no time for sleep. Plenty of time to sleep when you're dead.
That's true.
That's what my ex-wife used to say that all the time. She would say, there's plenty of time to sleep after you. In any event, before we get into it this week, I wanted to go through something that I thought was lost in all the coverage. I mean, obviously the verdict came down. There was a lot of coverage about the verdict, about the huge crowds, about people's reactions. A whole bunch of jurors have now spoken out. So this was reported. The cost of trying the Karen Reed case a second time was in fact reported. And I'm not giving the media a hard time for that, but I think it just kind of got buried in the rest of the news. Mr. Brennan, the special prosecutor, was originally hired at $250 an hour, which I guess, Mark and Yoli, that's not outstanding or outlandish for a Boston attorney, really, is it?
I mean, I'm used to New York standards, which are probably the highest in the country, certainly, but I don't think $250 an hour is unreasonable for hiring a top-level attorney in Boston. The larger problem is why pay any money for a prosecutor when you have salaried people there to do that. I think that's the larger issue.
Yeah, I agree with you. So the initial contract, and I remember this was reported in the fall of 2024 when Mr. Brennan was first hired. The initial contract was capped at $75,000, but that has been amended several times, and only through the end of January of 2025, Mr. Brennan was paid $234,545. And that was only the end of January. So now we have March. We have trial preparation. The trial starts in April. The trial goes, 8.5 weeks? April, May, into half of June. And so the conservative final estimates are that Mr. Brennan will be paid between $400,000 and $500,000. But there's more. The Commonwealth, as we all know, hired Aperture LLC as the experts, and their total for blue arm paint and buying themselves a nice Lexus is $400,000. That's the estimated total. The Massachusetts State Police numbers for the second trial aren't out yet, but the total for the first trial was $210,000. That was just for their costs for security. Courthouse security in Dedham at the Norfolk County Superior Court. The total for the first trial, the second trial numbers aren't in yet. That was $258,278. The Dedham Police Department spent $91,000 for the last trial. And for this trial, the estimate is $84,000. So big money, don't you think?
It's a lot of money for 2 trials and no convictions. The taxpayers are the big losers here. I mean, what else can you say? This is an extraordinary sum of money, and close to $1 million of it was on for an extra prosecutor and terrible expert witnesses. And the return on investment, or what they paid, close to $1 million for a special prosecutor and Aperture. I mean, what a colossal waste of money. They're entitled to it, more power to them. But again, the question is why? Why did they do this? Why did they spend that money to go after this, to get this result, which was really inevitable? This was going to happen, and just seems like a big waste of money.
And for an OUI conviction, I mean, early in my career, I did a fair amount of OUI defense, not so much anymore. But I mean, I'm not going to say OUI is a good thing, and I'm not going to say it's a run-of-the-mill case, but it's a run-of-the-mill case. It's not. It doesn't really. It's usually. Usually it's a prosecutor. They talk to the cops. There might be a couple of cops, and the costs are nowhere near that much. Yolie, you agree?
Oh, yeah. I mean, that's a lot of money. That's outrageous. And I wonder if it was just because Mr. O'Keefe was a cop and they just wanted to make an example of somebody who had nothing to do with it. I mean, I don't understand it.
No, Mr. Proctor said, let's get the girl. So this judgment came, or I should say this verdict came down on Wednesday, June 18th. Now in Massachusetts, we lawyers all, if you care, get a publication called Massachusetts Lawyers Weekly. And every lawyer I know, reads it. They call you on the phone. Hey, did you see this article? So the next Monday, there was nothing in the paper at all about this. And I was kind of shocked by that. But then I found out why. The electronic version came out a couple of days later. And lo and behold, there was an article where they had their own panel. It's not as dramatic as seeing it on TV. But Massachusetts Lawyers Weekly had an article, Experts Karen Reed Case Raises Legal Ethical Defense Issues. And I'm not going to go through the background, which they printed. They had a panel of folks, interrupt me at any point. The panel included former Superior Court Judge John Liu, Mass Association of Criminal Defense Attorneys President Shira Diner, Michael Kendall, founding partner of the Boston office of White and Case, and he's also a former U.S. attorney, Daniel Medwed, well-known in Boston, criminal law professor at Northeastern, Boston criminal defense attorney Benjamin Urbelis. So that was the panel. And Mark, and Yoli, what I found interesting is just a couple of these questions. One was, considering how Karen Reed's 2 trials played out, should defense attorneys now more strongly consider mounting a social media campaign to fund the defense and seed the jury pool in the appropriate case? First of all, I thought it was a stupid question, but Mark, what's your answer?
Yeah. I mean, my first comment, shaking my head, was, who the hell is asking these questions? It's a loaded question. It assumes a lot. And obviously, if you try to seed the jury pool through social media, I mean, that's unethical. So I don't understand the premise of the question. There's certainly nothing wrong. If you just scroll back up to it for 1 second, just wanted to see the rest of the question. There's certainly nothing wrong with using social media to help fund the defense. That strikes me as not inappropriate if people want to raise money and donate and they want to learn about a case. But I'm not sure why the question would be posed as seeding the jury pool. And then in looking, I guess I'm trying to look at the answer here, where Judge Liu says, asking people about their interest in true crime, fake names they use, sequestering. I don't understand the question. I'm sorry. I just can't. When he continues to say, to turn this into pro Karen Reed bloggers that are doing things wrong, I just don't get the point of this.
Yeah, Yoli, chime in whenever you want. But my first impression was, social media is there. It's been there. It's huge in 2025. People with greater pay scales than me in the media world have said that in 20 years, people will not be getting their news from newspapers or any other old mainstream media anymore. They'll be getting it all from social media. So the question, I have a problem with the premise anyhow, because I think a lot of bloggers, and not just your client, Mr. Aiden Kearney, a lot of bloggers and social media podcasters just had an interest in this case. They had a real interest in the case. They had an interest in justice. They had an interest. It's an obvious, an interesting, fascinating, story, and that's just the way it is. I think the goal was simply, it's a fascinating case. Here's what we're doing. Some people are just so protective, and we do have to be protective of the jury pool. I'm not saying we don't, but people are so protective. I've had comments in my comment section. I think a lot of them are people from the UK. We shouldn't have any pretrial publicity at all. We don't think that there should be any, from the time a person is arrested until the trial, we don't think there should be any publicity at all. And that's an extreme view.
Well, this is America, respectfully, and there's a First Amendment right to and a presumption of open and public court proceedings. And that goes for any case. It just turns out that the case against Karen Reed was a hell of a lot more interesting for any number of reasons than a garden variety, operating under the influence case that nobody may care about. So we can't just shut off the public because this case may be interesting to people. If there are media coverage, whether it be the Boston Globe or whether it be internet journalists, whoever, that's the way the world works. The proceedings are open. If it's a matter of public interest, so be it. That's not any particular defense's fault. In fact, normally it would be the defense who would be more concerned about any publicity attendant to a trial than the prosecution. But, as you saw with the Karen Reed case, everything is upside down. It seemed to be people favoring the prosecution who were more upset about the coverage because it was overwhelmingly so favorable to the defense, which is very rare.
Well, Yoli, last week I think we talked about how out in Idaho, despite massive national, international publicity in the Chad Daybell and Lori Vallow trials, it took some time, but they got a fair jury out there. Karen Reed certainly got a fair jury. We have to say, if you listen to what the jurors said, isn't that an odd way to couch the question?
Oh, I think so. It kind of implies that the jury was, tainted in some way by social media. And when you hear the jurors speak out, they just listened to what came from the witness stand. And they also had a question about whether the videos of Karen Reed were evidence, because in those videos that Mr. Brennan played, he kind of sprinkled them throughout the trial. They asked, is that evidence? And I believe they asked that because she talked about drinking and driving. And so they wanted to know whether that was evidence. And I think that was a pretty logical question for people who are on a jury who are not necessarily, lawyers and they just listened to what came from the witness stand. They didn't talk about any conspiracies. They said that wasn't their job. They simply just didn't prove that a collision even occurred.
Yeah, exactly.
And I don't know why people can't accept that.
I have news for anybody that thinks that the big three-letter networks, command some kind of overarching control over America's groupthink. I've talked to people that hadn't heard of the Karen Reed case. Believe it or not, I live in southern New Hampshire, right on the cusp of the Massachusetts border. I have an office in Methuen, which is in the Merrimack Valley of Massachusetts. I have talked to people that didn't know about the Karen Reed case. So that's how much the publicity really affects people.
Wow.
Go ahead, Mark.
No, that's stunning that anyone in Massachusetts would not have heard of it. Out in New York, anyone that any lawyer I know and other people had all heard about it. And it even, it did make its way into the New York Post, which people out here read somewhat regularly. Their coverage, incidentally, was not very favorable to Karen. It was more unfavorable, more sensational. But I found very few people that had not heard of it. So that's interesting.
Well, you travel around in high circles. I sometimes, I'd like to think I do too, but I speak to the hoi polloi. Let's move along. Do the Karen Reed trials speak to the value of using a kitchen sink defense, Why or why not? And Mr. Medwood said, not necessarily, because the second trial seemed tighter and more targeted than the first, in that it emphasized reasonable doubt and did not fully develop the third-party culprit angle, even with within the constraints imposed by the judge. In essence, the strategy seemed rather straightforward. Insufficient evidence of the car having struck him plus flaws in the police investigation equaled reasonable doubt. Mark, I think we've talked about this before, but does this, one of the questions I was going to ask you later on was, we hear defense attorneys say, well, let's throw as much mud up on the wall as we can possibly throw and see what sticks. Does this kind of change the paradigm into, no, let's fight back and be aggressive?
I don't think so. I mean, I think this question is also another loaded question that's not apt. I don't think it was a kitchen sink defense. I think at the end of the day, the defense was there was no collision between the car and John O'Keefe. And yes, there were components of other suspects that were not investigated and a very poor police investigation. But that goes hand in hand with, if they had done a proper investigation, they might have seen that there really wasn't evidence that they later cited as supporting a car collision. I just think they did it the second time around the right way. And I'm looking at Judge Liu's comments on this question and saying that this was a time-honored kitchen sink defense. I think that is absurd. That's not at all what happened here. And I'm just shocked that a member of the judiciary, a retired member of the judiciary, would see it that way. It's to say that there's nothing to learn from this and that there was a potent Bowden defense. Well, that seems inconsistent with what you just said a minute earlier about there being a kitchen sink defense. And then there's this comment about true crime enthusiasts on the jury. And what a ridiculous and offensive thing to say. Respectfully, by a judge calling into question the integrity and credibility of the jury as a retired judge. I mean, that is dangerous for somebody who, has that title of retired judge to consistently attack the verdict, attack the integrity of the jury, and kind of label them as, true crime wackadoos. I just think that's inappropriate. And you've seen since the verdict, I don't blame the judge for this, obviously, but some of the attacks on the jurors, like just the relentless attacks, but judges criticizing jury verdicts and dismissing them as true crime enthusiasts, I think is just way out of bounds.
Yoli, what do you think?
Yeah, I think I agree with Mark. I don't understand that mentality. Normally when jury verdicts are reached, the prosecution or the plaintiff or defense counsel, they usually say, well, we respect the jury's verdict. We expected a different outcome, but, the jury, after looking at all the evidence, decided, and so be it. You don't question the province of the jury. I mean, it's going to deter jurors from wanting to be jurors, or it's going to discourage potential jurors from wanting to be jurors on these high profile cases, which it's hard enough to get jurors on these cases, and then to attack them afterwards. That's not going to do any good.
You also saw, not that this relates directly to the question because we're talking about what Judge Liu said, but when you saw Brennan's statement after the verdict, that was probably the single most offensive statement I've ever seen a prosecutor after an acquittal make. It's bad enough to say, we lost because of witness intimidation that he perceives, and knowing that there could be other trials that could influence certain person you named earlier, their right to a fair trial going forward. There was no mention of jurors being harassed. But the real shocking part of the statement was, I investigated this case and I looked at the closed federal investigation, and only one person did I conclude did this. In other words, I'm telling you, it's my opinion Karen is guilty as part of your statement after losing, and she was overwhelmingly acquitted, and you've heard these jurors speak. That was grossly improper for what he said, and the worst kind of sour grapes, and just beyond unprofessional. And it doesn't help when you have judges and prosecutors trying to undermine the integrity of a verdict like this.
I was going to mention Mr. Brennan's statement also. In my last episode, I think there were 3 or 4 paragraphs. I read the first 2 or 3, and then I said that was enough. Because, as I've told you both before, I actually know the man. I've sat in the room with the man. I've talked to him. I used to call him on the phone and talk with him. And so when he was appointed special prosecutor, I DM'd him and he said, "Hey, Hank, what's going on? Why are you taking on this case? Andy, I can't talk to you. Ethical reasons. When the case is all over, I will talk to you." So last week, I DM'd Hank again, and he told me I decline your interview. So after I said that, I think this last episode or the episode before, I had commenters, Mark and Yoli, I had commenters say, "Why would you interview him anyhow? What is to be gained?" Well, as a former member of the Fourth Estate, I think, open mind, keep an open mind, give anybody a chance, talk to him. So this will be the last time I promise I ever mention this ever again. And you guys can jump all over me all you want. This is the last time I ever invite him to give me an interview. If he calls me and he wants to give me an interview, I'll talk to him. But I promise everybody this is the last time I'll ever say that.
I mean, my first question would be, why did you say that after the acquittal? I mean, that's just outrageous. Do that. And look what's happening to these jurors. And the irony is he's complaining about witness intimidation. Juror intimidation is just as bad, if not worse, right? I mean, if what's good for one is certainly good for the other, and you are feeding the flames of what's happening to some of these jurors. They're being harassed relentlessly, and it doesn't help when a prosecutor is furthering that along, or when a retired judge is saying they're just a bunch of true crime wackos. I mean, this is crazy.
No, it's uncalled for. Yoli, we're going to say something?
Yeah, I was going to say something. The witness intimidation thing, I don't really understand, because I don't understand how experts could get up there and do their little experiments that are less than scientific, in my opinion. How were those experts, is the blue man guy, how was he intimidated? He was a witness. And then the guy that, Shanon Burgess, I think, he lied, said he had a bachelor's degree. How is that witness intimidation? I don't understand that portion of the comments about witness intimidation. Certainly the other witnesses who testified, they might have been intimidated, but I see them intimidated by people that were in the house, not by people that were outside true crime fans. I don't know. I don't understand that part of it.
Tried to imply through questioning that the plow driver Loughran had been intimidated, but his answers couldn't have been more unequivocal and non-controversial. He said absolutely not. And if you heard Loughran's testimony, what's the first thing he said? I mean, I was contacted by defense investigators within days and told them right away there was no body on the lawn. I mean, the defense knew that in early February of 2022. So this idea that he was somehow intimidated and influenced into giving testimony favorable to the defense under the fear of, being blogged about, which he emphatically denied. So I don't know where this is coming from, at least trying to impress this jury with that.
Okay. I see
I'm sorry, go ahead, Yoli.
No, I just said I see what he's saying about the plow driver. Yeah.
Lucky Loughran, the plow driver. I can't say I have a favorite witness because, they were all important. But he has to be my favorite witness if I can pick one. I mean, how can you hate the guy that drives the Zamboni at the local ice rink? I mean, it's just...
He was as earnest, I thought, as a civilian witness could ever look. I mean, his demeanor, if you're a lawyer and you have a witness, what do you always want your witness to do? Use the same demeanor when you're getting grilled on cross that you do on direct. And I've seen very few witnesses in my life who have ever maintained as even an earnest keel as he did on direct and cross. I thought he was a very powerful witness and very credible.
And he really stood up to that accusation by the special prosecutor that you were intimidated, weren't you? No, not at all. Yeah. No, move on. Next question. And I think Hank asked the question about 3 or 4 times before he gave up. Mm-hmm. So now we return to this article, and the defense obviously derived great benefit from prying into State Trooper Michael Proctor's devices. Will clients expect defense attorneys to do this in every case? How should lawyers manage that expectation and the costs and potential benefits of seeking information? Wait a minute. One of the panelists corrected the questioner. The defense did not pry into Michael Proctor's devices. Rather, the FBI did. The FBI obtained Michael Proctor's phone through a grand jury subpoena during the course of their investigation. And later, both the defense and prosecution in Karen Reed's case got access to all of that content. So, yeah, don't you agree? It was a unique situation that isn't going to necessarily come up fourth hand?
Yeah, and once again, the whole premise of the question is flawed and biased. I mean, Michael Proctor's phones were accessed because the FBI, the Justice Department as a whole, was looking into his potential criminal conduct in relation to his investigation, and the government gained access to his phones and then unilaterally decided out of fundamental fairness to give the defense and the prosecution, obviously they have to give both, but made the choice to turn that over for use by the defense in the trial. I mean, so the idea that the defense is just going to be able to start randomly subpoenaing personal phones of police officers under a hope and a prayer that maybe something will be there, that's not going to be the case. There has to be an individualized need, demonstrated need, the likelihood of there being evidence there, and especially when you're talking about a personal device, there isn't any judge who's just going to start okaying subpoenas for police officers' personal phones. I mean, again, the premise of this question is just way off base.
Yeah, it was the FBI that got the information. So I don't. Yeah, the question assumes it has an assumption that isn't real.
Objection. Facts not in evidence.
Yeah.
Okay. So
Objection assumes facts not in evidence.
I'm going to jump down to the bottom, and here's the last question. Was it a waste of resources to hire Special Prosecutor Hank Brennan? Why or why not? And our friend Judge Lou says, in the beginning, I thought so. And ADA Adam Lally's excellent dry run in trial number one had inestimable value to Mr. Brennan's ability to try the bravura case he did. Wow. But at the end of the day, based on Mr. Brennan's stellar courtroom performance, I recant. It was a wise decision to bring Mr. Brennan on. Commenters, before I go to Mark Bederow, commenters, your thoughts. Mark.
It's a lot of word salad going on here. It's really hard to know where he's going with this. I mean, was it a waste of resources to hire Brennan? 1,000%, for the simple reason there is a large functioning district attorney's office whose salaries are paid for by the taxpayers. They have numerous homicide cases in Norfolk County that are prosecuted every day. They have high profile, all over the place, more than anywhere in Massachusetts, it seems. There's other ones going on. There's no conflict of interest. I mean, Adam Lally and McLaughlin were sitting there the whole first trial and the whole second trial. So there's no conflict of interest. Lally was at least capable of trying the case. He tried the first one, maybe, not as effectively as or as interestingly as people would say, although some would say he got a better result than the second case. And maybe that proves something. I don't believe that. I think the second case was different for a lot of reasons. But I don't know how you can ever justify, if you have a fully functioning, credible DA's office, bringing in a ringer at close to $1 million or $500,000 when there's no conflict of interest and you have capable people to do it. And I can't see any scenario that would say that that was an effective use of resources. I mean, if this was being tried in Mayberry and you had, one prosecutor and it was the murder case of the century, I think everyone could understand the need to bring in those kind of resources. But that's not a problem here. That's literally not a problem. This was just a colossal waste of money. And the result was worse than the first trial. And again, it is what it is. I don't know that you can fairly say, was it worth it or not based on the result, but I don't think you could ignore it either. They wasted money that they didn't need to waste and ended up losing and without a conflict of interest, also paid the salaries of the 2 prosecutors from the first trial. As a taxpayer, I find it ridiculous.
Well, even worse than that, and that's bad enough. But if you go all the way back to October of 2024, Vanity Fair printed an article about the case and said that the reason they had to go for the special prosecutor is because none of the other top prosecutors in the Norfolk County District Attorney's Office would try the case. And that is true, because I called that office. I spoke to somebody who refused to comment. He referred me to some press release that had come out in September, which had nothing to do with the case. And so that day, October 30th or 31st, I forget, I faxed over to their public fax number that's on their website. This can't be true. And I talked to a Boston reporter that I know, and I asked him, this can't be true. He said, Andy, I'm trying to get to the bottom of this. Neither one of us ever got any answers. So that means that it's, but how can that be? How can it be that people that are paid on the state dole can refuse to do their jobs?
Well,
I don't.
If that's true, and that's a question that I've been asking people in the media to ask repeatedly, that's the real scandal. I mean, if there's no one willing in the office to do it, that ought to tell the elected official that maybe you're looking at this the wrong way. I mean, I doubt that the people that are capable of doing it and don't want to do it are not doing it because they're afraid or they're, going to get embarrassed. I mean, look, you're a professional litigator. You deal with homicides. You try the cases. But if they're all not doing it, the key question is, why won't they do it? It may be their job. It may not be. If they don't believe it's ethical, if they don't believe it's warranted, if they don't believe the evidence supports the prosecution, then I would suggest they're doing the right thing by saying no. I mean, the worst thing you could do as a prosecutor is try a case that you don't believe ethically should be brought. So the real scandal here is if all of these people are telling the elected official you shouldn't be doing this, and he just keeps plowing ahead to the point where I'm going to spend all this taxpayer money and bring in a ringer who's going to aggressively try it in the way that Brennan did. Really, it's a fitness issue for Morrissey. And if that's the case, then he's not fit to be DA and he should go.
We did a show on that. I remember where we talked about that, how the prosecutors in the DA's office, they didn't want to try this case. They refused. And we didn't, I mean, I there's a number of reasons why they might refuse, but one of them could be that they didn't think it was ethical, because I didn't see the case ever. And I didn't follow the case as closely as you guys, like with the social media and Turtle Boy and all that. I was just looking at the court proceedings, and I watched part of them last year, mainly the experts, because nobody witnessed what happened. And so it has to be reconstructed in a way that makes sense. And I can never make sense of it.
No, a lot of people couldn't. Mark, one of my questions for you is, my commenters say this case sets precedents. This will change things. Well, that's my commenters. As you and I know, in law school, they teach us appellate law. They teach us what comes out of the United States Supreme Court, the Supreme Courts of the states, the appellate courts. That's what makes law. What, if any, I hate to say it that way, but what kind of precedent will this case set in that it was resolved in the second trial at the jury level? Any?
You hope that it would encourage future prosecutors to take a deep breath and realize that before you dive in and try to send somebody to prison for the rest of their life, that you actually have a credible, provable case. I mean, there's no precedent legally to this. It's just a trial that ended in an acquittal. But in terms of a message to prosecutors on what you should be doing or not be doing, yeah, the lesson is it helps to have evidence. When every medical doctor and engineer on the case is telling you we don't see scientific evidence of a collision and that's your whole case, then maybe take a deep breath and say, maybe I shouldn't be doing this. When you know that there's another police officer from another department who has no skin in the game, and he's saying that, look, that taillight was not in the condition that the state police were saying, maybe take a deep breath and say, that's also troubling. Same thing with Lawford, the plow driver. There's no body out there. That makes no sense. These are not things in isolation. I mean, you could go on and on. You factor in, all of the messages from Proctor obviously are a terrible thing. you have a case where you're not even willing to call the lead investigator. The other cops you call are not even willing to acknowledge the obvious that he was the lead investigator. I mean, this is just the lesson to be gained from this is to put this on a video and present it to young prosecutors and say, we're going to watch a video. And the title of the video is How Not to Investigate and Prosecute a Criminal Case. And that's what this is. I mean, how not to be an elected official in charge of public safety in a county. This is exactly that. So everything about this prosecution is just gross. And it's a terrible example to set for other prosecutors in bringing credible cases, trying to keep the public safe as they should. I mean, you want ethical, good prosecutors to stop crime and dedicate resources where they go. What you don't want is this fiasco, which is what this really was.
So that was a great answer to my question about, what we learn in terms of substantive law in law school. But there are trial skills classes. I still remember mine. And,
Yes.
I would guess that this trial will be shown in trial skills classes. Some of the cross-examination, I mean, the entire defense team was great, but Robert Alessi stood out in my mind in his ability to dig down into the actual science, not just saying, trust the science, trust the data. No, he dug into it. And I've heard him speak elsewhere about, his background, as a pharmacist really helped him and gave him a special skill set that was a tough class. I mean, we went through a lot in law school and studying for our bar exam. But in addition to all that, before that, he did his work as a pharmacist. So I think his work, but the work of others, I think Alan Jackson's close was outstanding. Yannetti was outstanding. Elizabeth Little did a lot in the background. So my guess is that this case will be in the trial skills classes in the CLE seminars.
Yeah. And again, with good things and bad things. I mean, I've never seen a lawyer who's dealt with experts on an intellectual level that Bob has. I've just never seen that. I mean, usually when lawyers deal with experts, especially adverse experts, if they're cross-examining, there's only so far you can go. And if the expert starts talking over you, normally most lawyers at some point, you're just not going to be able to keep up on the subject matter like he did. I've never seen a lawyer know the expertise subject matter in different subject matters, as it were, as well. So I think he was incredible. Obviously, I think Alan is one of the most gifted trial lawyers I've ever seen or ever will see. But you also can learn how not to do things from watching trials. It's not all good. Look at the way Brendan was treating experts.
Let's not talk about the ham sandwich. Let's not talk about the ham sandwich anymore.
But that's an important lesson because he's an experienced lawyer too. And, why would you be so petty with these experts and be so snivelly? And that's an important lesson. He just lost his way and just kind of misread the room, so to speak, in going after them with nonsense. And young lawyers and trial lawyers should know, pick your fights and stay focused. That was not focused.
And the key example of, maintain control. When you're doing the cross-examination, you're in control. And a moment that really stood out to me, I forget which one of the Aperture experts was on the stand, and Robert Alessi was cross-examining. And the expert on the stand say, let's go to the next slide. No, Alessi said, no, I'm asking the questions. I'll tell you when we go to the next. And that's really important. If you're doing a cross-examination, you have to maintain control and ask those, questions that demand a yes or a no. Yes. Shut up.
Yeah, it's yes or no.
Yeah.
It's yes or no.
So, Mark, you speak to a lot of folks all over the place and network TV and everywhere else. And one thing that really struck me when the jury foreman finally spoke out a couple of days after the trial, he was on he was on NBC Today Show, I believe. I get him mixed up because I watch him. I'm a media student, so I think he went on the Today Show on NBC. The foreman of the jury explained that there was a sloppy investigation, but moreover, the important thing to the jury was that the evidence just was not sufficient. It was insufficient, and there wasn't enough evidence, and there was a lot of probable cause. And for that reason, the jury unanimously found Karen not guilty on the major charges. And the ABC interviewer said, well, then who did it? And he shut her down and said, that's not our job. Our job is to weigh the evidence and evaluate whether they've met their burden of proof beyond a reasonable doubt. And so I thought that showed that this jury did their job more so than jury one, but it also showed me, I don't want to say it was a stupid question, but I mean, how are people at such high levels of the media asking questions like that?
I don't know. I know Court TV had put up a similar analysis about, the juror said essentially that if I knew Karen was innocent at the beginning and the end, of course, recognizing there's a presumption of innocence that stays with the accused unless and until, they prove beyond a reasonable doubt to your satisfaction, whatnot. And Court TV talked about that as if that was a controversial topic, when, of course, that's how every juror is supposed to do it. They had to delete the tweet because people were just clobbering them. Same thing with the interview of the foreman. My takeaway from it was very reassuring and refreshing as a lawyer to see, especially in a case like this, that he got it. And if you saw the interviews of some of the other jurors, they all got it. I mean, they did exactly what you would want a jury to do: evaluate the evidence, look for reasonable doubt or not, and just render a verdict based on that. And who did it? Not my bailiwick, not my concern. I mean, you could be worried about it and think you'd like to know, but that's not their job. And he recognized that. The other jurors recognize that. And it's shocking to me that there's any controversy at all, when at the end of the day, this seems really simple to me. A jury heard a case. There is reasonable doubt all over the place. The jury concluded after 4 days, 2 notes, that there was reasonable doubt all over the place and acquitted. I mean, that's what they're supposed to do. That's not controversial. That's ordinary.
Exactly. Yoli, any thoughts before we move to our viewer comments?
No, just the people have trouble with the presumption of innocence until proven guilty, and that's what every defendant is afforded. And they seem to think that that only applies to the jury. Well, yeah, the jury's instructed on that, but we, as the public, need to know that people need to be proven guilty, and it's the state's burden to prove it, or the Commonwealth's burden. So I don't really understand why that's controversial.
I don't either.
It's
Mark,
not.
you have time to? No, it shouldn't be. Mark, you have time to
Right.
stick around for our viewer comments?
Sure.
We only have 5. Okay. Yoli, do you want to take the odd ones and I'll take the even ones this time?
Sure. This is from Karen TKH6SY. The foreman of this jury was very thoughtful. I loved hearing him say that he considered her innocent up until they proved her guilty, which they didn't do. Very intelligent and wonderful hearing he and the others took their duty very seriously.
Yeah, Mark just commented on that.
Yeah, 100%. Yep.
Number 4 from Kelly Wilkins. A major trial televised, and the prosecution thought they could get away with this farce.
Well, this is why it's important to have public access to legal proceedings. Light is the best disinfectant to everything, right? You can't do these things in the shadows, and the public has an absolute right to know what their prosecutors are doing, how people are being prosecuted, and what for. And this case is a perfect example of that. And it is scary as hell that in a major case this high profile, you see some of the shenanigans that were going on here. And it does make you wonder what happens in the cases that are, in the shadows.
Yeah, the district court cases, the lower court cases, the everyday mundane cases. A lot of cases go through the courts in Massachusetts, as you know. Tons of, you've been over there to the Norfolk County Superior Court in Denham. A lot of cases go through there every day, every single day. And, good point. Okay, so the next one is great.
Julie Fernandez. Thank you, Andrew, for all your knowledge of this case. I feel that a lot of people say there was no justice because Karen wasn't convicted. She is innocent. What they should be upset about is the horrible investigation they did to cover up what really happened. Rest in peace, Officer John O'Keefe.
And I apologize for slipping that self-serving slide in there. But anyhow.
Now, I mean, this is a valid point, and this triggers a lot of the people. But the reality is, for the people that are obsessed with Karen is guilty and, she's the cause of cancer and global warming and just this awful, awful person who is all evil in the world. If they think she's guilty of this and quote unquote got away with it, which I don't think is the case. I think she's innocent of this. But
I do too.
if you are upset and you think she got away with it, your primary anger should be looking at the Norfolk DA's office, the Massachusetts State Police, and the Canton Police, because they botched this case up and down from the very beginning straight to the very end. And this was involving, the investigation to the death of a town resident and police officer. And what they did in the early stages of this was disgraceful. And the way they prosecuted it up to the very end was shockingly incompetent. I mean, look at the experts they hired, the witnesses they called, the witnesses they didn't call. That they get the blame for this. That's who you should be blaming if you're upset, if you think she got away with it. The system worked. There was reasonable doubt everywhere. That's how it works.
I agree 100%. Julie says they didn't just find a body on a random lawn either. John O'Keefe was invited to their home to attend an after-hours party. John O'Keefe arrived to that party, was never seen alive again, and discovered hours later dead on the front lawn. That's what makes it so much more egregious. The police would search the house if it was a random lawn. Of course they are searching if the victim attended a late-night house party.
Whether they search it in a criminal procedure sense, is there probable cause? Do you seek consent? Those are all interesting issues that certainly they should have at least explored. But the thing that bothers me even more than that is their complete lack of intellectual curiosity to just say, did anybody see anything? Does anybody know why he has one shoe, where the glass came from? Whether, again, it's a matter of search and seizure, getting a right to search or this or that, where was the just basic police interest in, did anybody see anything? And cops are always nosy in that regard. They're skeptical of everything, as they should be, as you want them to be. And in this case, it was, no harm, no foul, nothing to see here. Let's go get breakfast at the diner and get out of here. I mean, that's the impression they gave.
Well, as the jury foreman correctly pointed out in several of his interviews, if a dead body was found on his front lawn, they'd be in his house in less than a second. I mean, come on now.
You know what? And jurors bring individual experiences in. They don't check their common sense and personal experiences at the door. And, that was a very interesting point he made, for someone like him to say, if that was my house, what would happen? And, I think that struck a chord with a lot of people.
I have a few law enforcement in my extended family and also in just people that I know around town. And I've asked two of them in specific, if you found a body on my front lawn, wouldn't you be coming into my house? Absolutely. Absolutely. And I don't think there's a judge in the world that wouldn't, if I didn't let them in, I don't think there's a judge in the world that wouldn't grant them a warrant.
Or at least, again, knock on the door. Say, did you guys see anything? Do you even know how he ended up there? Or was he supposed to come over? Did he ever come inside? Where's his coat? I mean, I know he didn't have a coat. They just swept it under the rug. I mean, this felt like a complete whitewash from the get-go.
It's just fishy. As you said, don't police have just basic curiosity? So it's just fishy. I'm sorry.
Yep.
Okay, this is from Nancy Korensek. No accident report was ever filed. At the very least, Canton owes Karen a new car.
Well, I wouldn't hold my breath for that, obviously. But
of course not.
There's no evidence, no credible evidence of a collision. And they just tried her for murder for a car collision where they have no witnesses, no medical evidence, and no credible engineering evidence to back it up. I mean, it's in many ways insane.
I wonder if the reporters will follow Aperture. What will happen to that Lexus that they bought? What will happen to? They said they're going to sell it. They said they're going to sell it and give the money back to the Commonwealth. But I'm not holding my breath until that happens. Are you?
No, but I think also for Aperture, that's kind of like a third world problem for them. They've got a first world problem for themselves, which is their just general credibility. I mean, I think if you ever did a winners and losers, autopsy of this case, that, Aperture is front and center in the losers column. I think they are severely damaged as an organization for their quality of experts and quality of work, and frankly, sketchiness with changing opinions mid-trial on their own, we're told, which I don't believe, by the way. I just think that can't be true. They did that on their own.
Nobody believes that.
No.
Go ahead, Yoli. Did you have another comment before we move on? We're almost done.
I'm fine.
Okay. So our final scorecard, the number of countries from whom we've had comments and questions, 73. Somebody from Jamaica commented just this morning and kind of reamed me out because they had said that they had identified themselves as being from Jamaica and they'd commented and I didn't put it on the list. So here's our final tally. I'm just this little podcast, and we understand we're growing, but we're a little podcast. We're not one of the big guys. Even so, we've had people from 73 countries comment or question about this case, as well as all 50 states, District of Columbia, Puerto Rico, and Guam. So, don't let anybody tell you that the world is not watching this case, because, clearly they are. Okay, Mark, any closing thoughts for us?
No, I mean, this case is over. People ought to just let the jurors be. It's over. It was a very high-profile case, very emotional for a lot of people, but it ended. The jury rendered a verdict. It's over. So really, there's no reason to continue all this controversy. I mean, lawyers are going to talk about it, obviously analyze it like we were, but it's not healthy to just keep complaining about the result and arguing online and all of this other nonsense. Just it's time to move on and find something else to do. And for the lawyers, you go to the next case. I mean, that's what we do. And people who follow this should do the same thing. It's not healthy.
Yeah, David Yannetti said he's already been in court on other cases and people recognize. Of course, they're going to recognize you, dude. First of all, you've been practicing law for 36 years. And second of all, of course, they're going to recognize any lawyer. I don't know a lawyer that hasn't followed this case, but step down, next case. All right, Yoli, your closing thoughts.
No, other than I don't know why anybody would be surprised that she was found not guilty on the major charges. It seems I've never understood why they brought this case, and I'm a civil attorney. I don't do criminal law, but I just never understood it. So,
yeah. Well, I do criminal law, and I never understood it either. So we've got the criminal and civil expertise covered in that regard.
I did a lot of criminal earlier in my career, all those many years ago, and I really don't do that much of it. I still do a little bit of it. I do a little bit, but I'm largely civil at this point in my career. So thank you very much for joining us. If you've learned anything, or if this has opened your eyes, or if you've enjoyed the program, please be sure to go down in the corner and like, subscribe, and share. We appreciate that. We don't try and sell stuff on this channel. We don't sell mugs. We don't sell T-shirts. We don't tell you about financial advisors. The most recent thing I saw, Mark, was someone was selling aprons. That's fine. All we ask you is to give us a subscription and go down to the bottom down there and do it. It's free. Thank you very much for joining us, and we hope to see you again in the next episode. As soon as I find my outro, I'll go to the grocery store.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
Defendant not guilty or guilty? So say you, Mr. Foreman? So say you all?